Here with me is Attorney Ramon Esguerra, the defense spokesperson and defense co-counsel. Attorney, please describe what you think the day was in one word.
One word, great.
Great. Okay. Okay, let's start with the Basagadate issue. Could you explain to us the relevance of the $34 million check?
30 million peso,
30 million peso. Peso, not dollar.
not dollars, because central bank may run after us. No, the Basa Gidote check came out simply because the witness does not seem to know what he is testifying on in connection with the SALN issue. And so we were able to establish his competence, lack of competence insofar as proving that the 11 million peso, as the prosecution would like to have it, was fictitious. So that's their line. But apparently the witness that they presented on the matter is not knowledgeable. And there was an opportunity for us, therefore, at that particular point when Justice Cuevas was cross-examining this witness, that in connection with the expropriation, the only asset of the company, Basa Guidote Enterprises Inc., which is a piece of land in the city of Manila, was expropriated some time back. And for this, the compensation paid by the city government of Manila was about 30 million pesos. So, and note that the check, as it appears on the entry there, is payable to Mrs. Corona, no? In trust for the company, the Basa Guidote company. What that means is that even if you say that the corporation, Basa Guidote, already ceased to exist from the legal standpoint, it still has an asset under the care or administration of Mrs. Cristina Corona.
So it has that money.
It has that money. And, there were names mentioned on the basis of the, at least the limited, no, limited papers there on file with the SEC. The father of Mrs. Corona is there. The Vicente Rocco. So, there is an estate proceeding going on insofar as the inheritance issue is concerned.
So in terms of the Basagadate issue, you feel that you've made your point, no problem.
Well, you have seen how the other senators stood and how they saw the irrelevance once more of that particular witness or the testimony of that particular witness and the documents on record with the SEC.
Okay, and the issue also discussed later on was is it absolute sale, deed of sale, or is it the acceptance that determines the ownership or declaration of silence? And you were on the stand for that one. Can you tell us your perspective in terms of acceptance?
Well, they were saying that, they're questioning. Number one, what is very clear is that the Chief Justice declared the properties that are in question. Now, what they are saying, however, is that the declaration or disclosure made by the Chief Justice in his SALN of all these properties came late. Okay, but the fact remains, as I've been telling your other friends or colleagues in media, that there was a SALN filed and these assets were disclosed. That it is late is an issue from a legal standpoint. Was there compliance with what the law requires? So we cannot conclude at this point and should leave the matter to the Senate to resolve whether or not there was compliance with the law on the requirement. Now, but for us to say at this very early part of the trial, even if we are already on the 10th day, that that is not true, that is inaccurate, there is under declaration and so on and so forth, is too premature at this point in time. Why? They are not done with the presentation of the witness, primarily, of course, because they have the burden of showing that there was indeed gross inaccuracies on the basis of the SALN vis-a-vis all these documents that they have presented regarding the properties. And we have not presented our side of the controversy yet. No, so we are still in Article 2. They are not done. We have not started presenting evidence. They're not done with the other articles. We have not presented our evidence. Too early, too early.
So it's not unusual that between 2004 and 2010, it wasn't declared one. And two, does it usually take that long to check if there are defects or, for reinspection? It's a span of 6 years.
It was a running, if you may, I may use the word controversy over the unit, no? That also happened in connection with Bonifacio Ridge. And, ordinarily, if you're a buyer of a condominium unit, you would like to buy something that, that you can immediately use. But if there are defects, as in the unit bought in Bellagio, for a very low. I mean, there was a price adjustment. There was basis on the part of developer. So it was what was agreed upon by the parties as to the contract price. And then the same thing is true with respect to the unit in Columns. Why? Apparently, it was used as a bodega, and that is the subject matter of a document which I cannot mark in evidence during my cross-examination because the witness does not have the competence to confirm that he knows about the problems. Apparently, she has not visited the unit and therefore is not in the know of what the actual situation of the unit is.
So there were defects in the unit.
Yes, there were.
Or that's what you were trying to.
Yes, yes. At the appropriate time, we will complete this particular angle and establish that that is so.
And we can expect the documentary evidence and everything else.
Well, we may have to subpoena other officers of community innovations insofar as this issue of the unit is concerned.
But the point is that if the unit was disclosed.
Yes, that's right. It took a little time because there was really a substantial issue on the part. I mean, from the point of view of the Coronas about the unit that they bought. Okay.
Great, thank you so much.
Thank you.
And that was defense attorney Esguerra. Thank you for joining us with Rappler, and we will